We've had this situation reviewed by experts. They do not believe we could have done a better job.
As the health department said, the allegation the hospital did not take prompt action was determined to be invalid.
You know, he has a great deal of empathy for this family. He's been practicing neurosurgery for over 25 years, and the patient actually improved as a result of this surgery from her underlying condition.
The most difficult part of these cases is, you know, you're sitting there trying them, and you could settle the case for $1 million, which sounds like a lot of money. You could lose the case for $15 million. And, you know, there's a lot of pressure. But if they have a supportive expert who's really supportive, and they think the case is defensible, and the client wants to go through with it, they will try this case to conclusion, and I would think that this one would be tried through to conclusion.
The family would not just walk away from Mr. Brophy. They wouldn't abandon him. They'd give him drinks of water if he were able to take it to keep his mouth moist, and they'd help him through the dying process.
My client takes strong exception to any type of discrimination in the workplace. This trial and this hearing the internal hearing took months to conduct. Literally, the staff review hearing here took literally months to conduct. Judge Gershengorn had hundreds of hours of review of this case. On the issue of circumstantial evidence, she actually did instruct the jury quite extensively on circumstantial evidence and felt that that fell under the rubric that the temporal relationship was sufficiently covered by that, and without pulling it out from under that. On the other issue of the filing of the MCAD complaint, I would direct the court to Record Appendix page 2642. The judge at that point is struggling with the issue of both the temporal relationship and the second issue in this case when she talks about then the reasonableness of the filing. And what she says there, and it really elucidates her thinking on the point at 2642, that it could be that it was the jury couldn't feel that it was reasonable based on his own feelings, question number one. Or it could be found, and she goes on to articulate this, there was a case Montero, which is a First Circuit case, which was cited in the brief. Or it could be found that it was taken as a preemptive strike to bind the hands of the employer from taking any further action in light of the fact that he knew further action might be coming, because once the complaint was filed, it would be retaliation per se if they were to take any further action. I would just suggest to the court in closing that retaliation is a very difficult issue now for employers to deal with in the workplace.
Thank you.